I Hate Politics is a podcast about a human activity we love to hate. I am Sunil Dasgupta. It is hard to live in America today without recognizing the enormous blow the Supreme Court has delivered to the body politic by overturning Roe v. Wade, the 1973 Supreme Court decision that opened the country to legal abortion and made women a little more equal to men. As women could then choose for themselves the right to be or not to be a mother, free from the authority of others, including the government, the church, and the men who fathered the baby. The project to dismantle Roe has been a long-running one in conservative and Republican circles. Led first by the religious right, the anti-abortion movement became mainstream about the time when Newt Gingrich issued his contract with America in 1993. And thereafter, almost all major Republican political leaders have been anti-abortion. What held them back from banning abortion was the Supreme Court, which held a liberal majority, and so the fight against Roe became the fight to control the Supreme Court. Trump's selling proposition to the religious right, especially given his own moral failings, was just this. He was going to appoint right-wing justices who would overturn Roe. Other major Republican leaders, including Senate leader Mitch McConnell, were firmly behind the project as well, rejecting, for example, Merrick Garland's appointment to the Supreme Court, which then allowed Trump to make his first Supreme Court appointment. When Trump replaced Ruth Bader Ginsburg with Amy Coney Barrett, even a vacillating Chief Justice John Roberts could not have held up Roe. The Supreme Court is one part of the anti-majoritarian political order where tyranny of the majority was a big concern. 2 senators per state irrespective of population, the Electoral College and later filibuster rules are protections against so-called mad crowds of populism and democracy. But what if the system was built to inflate minority power at the expense of democracy itself? And even if it wasn't built to undermine democracy, is it doing so now? The biggest tool in this respect, as the Supreme Court has shown in several decisions, is the power of judicial review that comes to us from the landmark case of Marbury versus Madison, which involved Marylander William Marbury. So for the 2022 Independence Day episode, I talk with Maryland State House Delegate Vaughn Stewart and UMBC history professor Andrew Nolan about the possibility of breaking the shackles of judicial review and other anti-democratic elements of our political order. But before we go to Stewart, Nolan, and esoteric law and history, a more obvious point. Wouldn't it be better to have more women in office so that there would be better protections for women's rights? We are a local podcast, so I talked to local blogger Julie Statland about having more women in Montgomery County and Maryland politics. Statland writes a blog called Riveting Women. As you listen, keep in mind that I recorded the interviews with Statland, Stewart, and Nolan after the Roe leak, but before the Supreme Court had actually released its final decision.
Let them stay your girl. You'll always have your own. But take something for granted and it will be taken from you. This I've come to know.
If you're new to the show, I Hate Politics is a podcast about our neighborhoods, workplaces, schools, and streets, and our local governments as they function in diverse and democratic societies. This means our politics are messy, dirty, sometimes corrupt, with often self-serving politicians, but no matter how much we may hate politics, we are never exempt from it, even when we refuse to participate. In fact, the purpose of politics is to keep society functioning precisely when we don't agree with each other, like now. It is my hope that this podcast will help those who feel left out reconnect in our local communities. Music for this episode comes from the Treading Lemmings, a Rockville-based Britpop band in the genre of the Smiths. Their music is available on ReverbNation.com.
I gave yesterday. And if you want to hear my take, let there be care. Don't stop one day. She's there, I say. Please won't you share? Come share my umbrella of shade.
Julie Statman, you have argued for more women in elected office in Maryland and Montgomery County. How do you see the field today?
Well, I'm excited for the bench, that's what people like to call it, the bench of women that we have running for office. When I first argued a year ago, almost, with an op-ed in the Washington Post, and I had said that there aren't enough women, and they're not supported, and the kingmakers and the queenmakers are not, pushing for women. And today we have a lot of women in front-running positions. We have a woman running for the Attorney General. We have a woman running for Comptroller. We have 2 women running for Congress. We have a field of women running for County Council. And we have House of Delegates. We're at 33%, I believe, maybe a little bit higher, of incumbents and women running. So the field is growing. Not the only area, I'd like to see more women in Congress. And we've never had a female county executive, and we've never had a female governor. So those 2 areas are lacking, but as an overall field, it's much better than when I was talking about it a year ago.
So what changed over the last year?
Well, I think that, I think a lot of people woke up, right? Like, we tend to take for granted that we live in Montgomery County and we are a liberal, and Maryland is liberal and has a lot of women's issues and women's rights. But when you look at actually some of the laws that are still on the books in the state of Maryland that are detrimental to women, and you look at some of the things that are going on nationally, I think women woke up, especially Democratic women, when they realized there was no governor, and then they realized that, and Brooke Learman was running for comptroller, and how accomplished she is. And you look around and you see we have a lot of accomplished women, and they're not throwing their hat in the ring. And so I think women in Maryland kind of woke up a little bit and realized that they too needed to make impact on our state. When you looked around the council, there was only 1 council member, and we were going to expand to 11, and she was term limited. So there was a chance of, again, having 11 men represent us in a council, in a county where 51% are women and 57% of the Democratic electorate are women, but we're not electing women. So I think people really just started to wake up and look around, not take it for granted.
There is a difference between ascriptive representation, that is having women personally at the table, and women-friendly policies being adopted. You're a Democrat, and the gubernatorial field on the Democratic side is all men. But on the Republican side, Commerce Secretary Kelly Schultz is the leader of the field. So how do you make a choice then? Do you go for ascriptive or sort of, personal representation, or policy representation?
What you need to run for governor is about $5 million in party support, right? So when you look at which party is giving the $5 million and having the party support, unfortunately, it's the Republicans for Kelly Schultz, right? Not the Democrats, whom I love, but that's not what's going on. So Kelly Schultz, who has a track record that's great, and people really like her. I met her, and I genuinely like her. But the problem with Kelly Schultz is that she votes for the Republican activist side of the party that does not provide that wants to get rid of Roe v. Wade. And so these are not women-friendly issues. And unfortunately, the Republican side of the party in Maryland also didn't vote for family leave. So, you want to force us to have babies, but you don't want to pay us to stay home and raise the baby. So, it's hard to vote for a woman that is promoting those policies. So when I say I want women in office, I want women in office that are going to do things that promote women and families, right? And promote the welfare of women. So unfortunately, I couldn't vote for Kelly because that's where the party line that she's representing stands. On all other issues, I think she's fantastic. She's fantastic on business. She's fantastic on other things, but not that issue.
But what about applying that idea to the local and legislative offices? And say some men that run for office say, I am the more women policy friendly candidate than the woman herself. How does that cut?
It doesn't. Like if you look at some of the policies that were fought, especially in the Senate under the judicial proceedings, marriage is still a defense for rape, and women can't get that passed. Single women have more rights than married women. And there were 2 cases in Montgomery County where the women were violated and their husbands were able to get off because of that. So could not get that passed through the judicial proceedings for the Senate, passed with a standing ovation in the House, not in the Senate. So when you say, where is that where we are? Well, we're not getting things like that done. There was another one where women were fighting these issues at the State House for 10 years for not having to raise a child with the rape victim having to raise the child with the women weren't even included. They weren't included in the discussion about moving it forward out of committee, right? Cheryl Kagan had to sit and kind of watch over them because no women was included. At the county level, we need representation for issues like that. And even just a different perspective, wages, housing. 70% of HOC are women. And we have a 2-year wait. And these guys are doing great jobs, but it's not enough.
Do you see any local candidates using the leak and the possibility of Roe v. Wade being overturned to propel their campaign?
It's a wake-up call that women need to be involved in the process, that we can't rest on our laurels. As much as we want the men to represent us, that we also have to have a seat at the table. So I think that there's going to be discussion about it. I think that it certainly women will be a lot more aware of what the consequences of not voting for women are.
Well, I see that women might get up and vote Democratic more readily as a consequence, but will that, do you think, translate into voting for a woman candidate?
I think for some it will. I think independents are what you're talking about. Women, Democratic women are going to get up and vote for the Democratic candidate, the pro-choice candidate. That's natural. We're all going to do that. Independents who can't vote in a closed primary in Montgomery County, for example, we're a closed primary. So if you're an independent, you can't vote in the primary, and that's where the elections are decided. So I think that you might see independents across the country who are the swing voters go Democratic in order to get in these primaries if they're smart. I think there also needs to be a push for millennials. So these are the people, the millennials and the Gen Zs, that's who's affected. They're the people who are of reproductive rights age. And if they don't come out and vote to protect their rights, and they could, 80 million people, that's kind of my point. 80 million millennials and Gen Zs can change the trajectory of this activist court decision if they want to. If millennials came out and voted en masse for Democratic candidates that were pro-choice in the primaries and in the general, then we could codify Roe v. Wade because we had congressmen and senators. It's a reach, it's a stretch, it's optimistic. But if millennials and Gen Zs decided that they wanted to come out on this issue, they could change the trajectory of our country.
Julie Statlin, thank you for coming on I Had Politics. Up next, my conversation with Maryland State House delegate Vaughn Stewart and UMBC history professor Andrew Nolan looking at judicial review.
Couldn't quite explain
Vaughn Stewart, Andrew Nolan, welcome to I Hate Politics.
Great to be here.
Thank you very much. Happy to be here.
Vaughn, I saw you outside a coffee shop recently, and you proclaimed that we should get rid of judicial review. Explain, please.
Yeah, of course. Well, I think you can have a range of different opinions about judicial review, right? You could say that there's some place for it. If you look across the world, you'll see that all democracies do judicial review a little bit differently and treat their highest court a little bit differently. I think, my position is that how we currently consider judicial review in the United States, what really I think should be referred, as judicial supremacy. I think the current status quo is anti-democratic. I think it's not working well for anyone, but particularly people who believe in democracy. And I think that now is the time to, in the wake of what's going to be a terrible decision on reproductive freedom and abortion rights, I think now is the time to take stock of where we are in the United States, about our separation of powers and about the extraordinary powers that we give to the Supreme Court, at least relative to basically every other democracy in the world.
Andrew, how did judicial review come about? And I'm asking you because you are the history professor here.
Well, first of all, I'd like to say, in response to what Vaughn said, I'm considering selling my house to move to District 19 so I can vote for Delegate Stewart. Speaking as a historian, one of the things that jumps out at you, of course, is judicial review is not ever mentioned in the Constitution. There are a lot of rationales behind it. And I think historically, there is certainly a strong case to be made that the courts must play some role in deciding what the law is. And the courts will confront the following problem. What happens when someone passes a law that runs clearly counter to a constitution? What should a judge do in that instance? And I think that is a situation that was set up in Marbury versus Madison. And the court's decision in Marbury versus Madison is that if the Supreme Court of the United States confronts a law, in this case, a federal law, one passed by the U.S. Congress, the Judiciary Act of 1789, if that law runs counter to the Constitution, that the court must rule the law out of bounds. It is unconstitutional and therefore null and void. That was what Marbury versus Madison found. And I think that's kind of the common sense understanding of judicial review that we teach from, say, middle school on upward. But notice that the phrase I used was set up. And I think one of the things that you learn when you look at Marbury versus Madison more closely is that despite what the Supreme Court wants, and paying homage to the title of this podcast, the Supreme Court was, is, and always shall be a profoundly political institution. So what happened? Here's what happened. Federalists had been the group in charge of the U.S. government since its founding in 1789 until about 1801. There were a lot of disputes within the party about what the Constitution meant and what kind of powers it gave them. And in the areas of basically foreign affairs and certain constitutional principles, a group of people kind of broke away from the Federalist position and formed a new group following Thomas Jefferson that came to be called the Jeffersonian Republicans. Later would become the Democrats and eventually the forerunners of today's Democratic Party. In 1800, Jefferson and his followers went head-to-head with John Adams, who was representing the Federalists, and his followers. And in a fairly decisive election, the Jeffersonian Republicans won. After that election, the Federalists decided one way to cement their position in the federal government was to, in essence, pack the courts. So they passed an act that allowed them to create a new circuit court level. And then they appointed judges to that level. And as part of that, they also appointed a number of justices of the peace who are fairly minor magistrates overseeing laws. One of the Federalist followers was a poor schmo named William Marbury. And Marbury was given one of these positions. He was going to be a justice of the peace in the District of Columbia. And I mean, this is kind of a big deal. It pays a salary. It's going to allow you to make a living. You can pay your rent in Georgetown. It's all good. The problem is, to get his position, he had to get the papers. And while he was appointed to the position, Adams and his Secretary of State, a guy named John Marshall, left office before Marbury could get his papers. So the incoming president, Thomas Jefferson, was supposed to deliver the papers. And Jefferson and his followers, who were livid that the Federalists had done this, had packed the courts in what they called the midnight appointments. They basically refused to deliver the papers. Well, Marbury was crushed. And so John Marshall, who had stopped being Secretary of State in order to become Chief Justice of the Supreme Court, convinced Marbury to file suit asking for what was called a writ of mandamus. It was basically a document that the court could write up instructing a federal official to do his job. In this case, to tell Jefferson, Secretary of State, give William Marbury his papers. Now, Marshall convinced Marbury to do this. He said, bring it up and it'll come before the court and the court will hear it. Jefferson, of course, is thrilled because this is going to be a way to basically gut the judiciary, which was widely considered the weakest part of the government, because John Marshall was going to issue a decision saying you've got to give Marbury his commission. And Jefferson was going to say, no, I'm not going to do it. And it would show the fundamental weakness of the Supreme Court. But in what was kind of a brilliant sleight of hand, Marshall found that, in fact, the writ of mandamus that Marbury was asking for was out of bounds, that the Federal Judiciary Act of 1789, which had given him this power, had overstepped the bounds established by the Constitution. Therefore, John Marshall said, I can't give Marbury his writ of mandamus. But to do that, in other words, to screw over poor William Marbury, he had to find a federal act unconstitutional, which he did. So to a certain degree, Jefferson won in that he was not being told what to do. But what John Marshall did, and I think this gets to Vaughn's point, is he set up a co-equal power for the judicial branch. In other words, what he said was the Supreme Court has the power to decide what the law is. But he didn't go further than that. In other words, to get to Vaughn's other point, he did not say the Supreme Court and only the Supreme Court has the power to say what the law is. He was saying since this act applies to the court's powers, the court quite properly can rule on whether it's constitutional. And this was part of a broader theory that was very prevalent in the 19th century called departmentalism, in which basically each of the three departments of government decided what the Constitution meant governing their duties. So Congress decided how the Constitution limited or gave them legislative authority. The president decided the same for executive authority. And in this case, Marshall was saying the Supreme Court gets to do that for judicial authority. And it was a power that was pretty important. There's a reason we keep going back to it, but it was essentially a negative power. He was saying if someone oversteps their bounds, the Supreme Court can protect its department by ruling that out of bounds. And it wasn't a power that the Supreme Court was going to use again for a federal law until the 1850s, when one of our most infamous Marylanders, Roger Brooke Taney, issued the Dred Scott decision.
Vaughn, can you bring us up to date from Dred Scott to now?
The Supreme Court has been a reactionary force throughout the thrust of its history, and there's only a couple of outlier cases where it is sort of ruled either for minority rights or ruled on behalf of poor people or vulnerable people at all. I think the question for me is, how can it possibly be legitimate to have an unelected body with the power to routinely overturn popularly elected or popularly enacted, at least, laws? I think the core of every democracy is the notion that it's the people through our elected representatives who should determine, policy decisions that affect our lives. And now we have a situation where we have a Supreme Court. Our justices are probably the most powerful in the world, and the consequences of their decision reach into basically every area of American life. So they determine whether people can have abortions. They determine whether teenagers can buy assault rifles. They determine whether poor people can have health care. And they determine whether a corporation should be able to outspend regular people on political campaigns. And I think that Americans, and especially people, liberals, progressives, people with my ideological persuasion, they tend to like judicial review when it promotes their own political values and hate it when it doesn't. But I think this is a mistake. I think that the truly progressive position is that judicial review, or at least judicial supremacy as it's been adopted in the United States, is an illegitimate way to make policy decisions in a democratic society. And I think that, what's so weird, I think, about the liberal response to the growing conservative majority that we're seeing, the possibility that we essentially are going to have an arch conservative court for the rest of my lifetime. I'm 33. I think that it's weird because I think at times folks strongly endorse the idea that the court should be in the business of striking down laws enacted by elected officials. But then at other times they view that as anti-democratic and deeply anti-majoritarian if conservatives do it. And so it's like, we clearly have this sort of what's good for the goose is not good for the gander, judicial supremacy for me, but not for thee attitude. And I think, when you look at the history of the court, I guess, going back from Dred Scott, what you pretty clearly realize is that we're not talking about neutral political experts calling balls and strikes here. We're talking about essentially except for maybe you can argue about 15 or 16 years in the middle part of the 20th century, you essentially have a long and uninterrupted line of judicial decisions favoring large corporations and wealthy people at the expense of everyone else. And so, and you also see that the court is absolutely willing to reverse itself in ways that completely go against any idea that they're really divining some sort of sense of like they're neutral arbiters of some sort of law that just exists out there in the ether. So, for example, judicial review is a power you can use to say school segregation laws are disallowed in Brown versus Board of Education 1954, or say that school desegregation laws themselves are disallowed, which is what they basically ruled in Parents Involved in 2007. Or you can use the power to say that laws restricting voting rights are disallowed, as the court ruled in Harper 1966. Or you can say that the Voting Rights Act itself is disallowed, which is what they ruled in Shelby County in 2013. You can use judicial supremacy or judicial review to say that laws restricting contraception are disallowed, which is what they ruled in Griswold in 1965. Or you can say that laws requiring insurance to cover contraception are disallowed, which is what they ruled in Burwell in 2014. So you can also say, for example, that campaign spending regulations are allowed, McConnell, 2003, or you can say they're disallowed, Citizens United, 2010. You can say that fair share fees for public sector unions are allowed, in Abood, 1977, or you can say they're disallowed, Janus, 2018. And now what we're seeing, obviously, is Roe versus Wade, 1973, versus what's going to come out imminently, which is saying that actually there is no constitutional right to an abortion and that states should feel free to criminalize people who go across state borders to get abortions and to bring them back, extradite them, and impose criminal penalties on them. And so, I think it's pretty obvious based on this arc of Supreme Court history that the sorting of laws into these sort of allowed or disallowed buckets depends almost entirely on the political ideology and the political composition of the court, and absolutely nothing. It has absolutely nothing to do, except in some cases that are sort of not political, with natural legal principles. And so, given the political complexion of the court, given that we essentially have 9 politicians in robes deciding things for us, I don't understand why there is such widespread agreement that the status quo is acceptable in any democracy.
If I can broaden the conversation a little bit, what other kinds of protections against the tyranny of the majority do you see as anti-democratic?
Our political system is littered with anti-democratic levers, right? So the filibuster is something that comes to mind. It's something that the framers, like judicial supremacy, never would have considered as a reasonable check on the power of the legislature, yet it has basically in relatively modern times come to be a fundamental feature of the United States Senate and has basically made it so that the United States Senate doesn't really do anything.
The Senate, I would actually argue, is one of the anti-democratic measures against the tyranny of the majority. Giving it the filibuster enhances its lack of democracy. It's not a guard against the Senate itself. It's a tool for the Senate to be even more undemocratic than it wanted to be otherwise.
Just to quickly rebut this argument about the Supreme Court and minority rights, because it is the one that you hear most frequently. When I bring this up to sort of my colleagues and friends, they sort of gasp in horror about the idea of chucking out judicial supremacy, because, it's really hard to break this kind of ideology that we were all taught that somehow, essentially popularly elected bodies will naturally succumb to the temptation to pass legislation that interferes with the rights of minorities, and that only the presence of the court and its extreme powers can block the tyranny of the majority to protect minority rights. If you look just at racial minorities, over the course of American history, the court, way more often than not, has been a regressive force on racial issues. Before the Supreme Court, they sustained the constitutionality of federal fugitive slave laws. They invalidated the laws of northern states that were designed to protect Black people from, or to protect free Blacks from the kidnapping by slave catchers. They avoided a congressional effort to restrict the spread of slavery into federal territories, and they denied that even free Blacks possess the right, which, quote unquote, the white man was bound to respect, or any rights in which the white man was bound to respect. And then after the Civil War, you saw, rulings about freeing the perpetrator of white on Black lynchings and racial massacres. The court invalidated a federal law designed to secure Blacks equal access to, public accommodations. And then, starting with the Burger Court, you saw basically the Supreme Court was rubber stamping a number of state-mandated racial segregation, Jim Crow policies used to disenfranchise African Americans, and then famously even sort of gutted its own decision in Brown v. versus Board of Education with some rulings on school busing. So, and then in contrast, basically, and a lot of times it's been elected officials who have led the way in promoting important human rights in the United States. It was the president who freed the slaves. It was Congress that established voting rights for minorities in most cases. Women, the elderly, the disabled, racial minorities have all successfully worked through elected branches of government to protect rights and free themselves from discrimination. And, when it comes to expanding rights beyond the Bill of Rights, it's mostly been Congress or state legislatures that have passed legislation to enact rights for consumers or workers or patients or the elderly. And so I think that at very best, the very best you can say is that it's complicated. And I think the worst you can say is that elected bodies, by and large, in the United States, have not a perfect, but a much stronger record of protecting minority rights than the Supreme Court, which, except for a couple of asterisk sort of outlier situations that we learn a lot about, has essentially been a force against racial minorities, against the poor, against the elderly, against women, and a force for the most powerful people in society and the largest corporations in society.
One of the things that we've lost sight of is the degree to which the 19th century was a robust era of debate about the Constitution in all forums, and that includes ordinary people. And one of the things to remember is that the U.S. Constitution is short for a reason and was written in plain language for a reason. It was not intended as a document for lawyers. It was intended as a document for everyone. The people were a source of constitutional interpretation. Judicial supremacy has kind of caused us to lose sight of that very active role that people should be playing. In other words, you should not think, well, I think that's a bad Supreme Court decision, but they're the lawyers, so I guess I'll shut up. No, that's the wrong answer. You absolutely should be informed. You should read the Constitution, but the people of the United States play a key role. And in fact, the fundamental role, ironically enough, those cases involving judicial review at the state level that the Marshall Court issued, like Martin versus Hunters-Lessee and McCulloch versus Maryland, went out of their way to point out it was the people, not the states, who were considered the fundamental authors of the Constitution. When we embrace judicial supremacy, we cede an authority as citizens that properly belongs to the people. They do play a role, not the only role, but a role along with the court. And I think that that's one reason why it's important to recognize, whether we're talking about enslaved people, whether we're talking about folks marching for civil rights, whether we're talking about women marching for equality or an amendment to the Constitution to getting the right, it is people themselves who, embracing constitutionalism, demand either a change in the law, a change in the fundamental framework, or a recognition of their own personhood and rights and responsibilities under that fundamental law and framework. But to add to your original question, Sunil, I would add the Electoral College to another fundamentally anti-democratic goal that's supposed to protect against the tyranny of the majority, but echoing what Vaughn said, actually ends up doing the opposite.
Does judicial review apply to state law?
I would say until recently, this was a fairly non-controversial question, and that is that Article 6 makes pretty clear the Constitution trumps everything. And early in the 19th century, the Marshall Court made clear that neither a state legislature nor a state judiciary could basically operate on its own. In other words, state laws were subject to federal constitutional review, state courts were subject to federal constitutional review. The Rehnquist Court, starting in the 70s and going to the 80s, really began to reinvigorate federalism. I would say that is no longer a settled question, and that now the court has begun to show more deference to allowing state legislatures and state courts to do what they wanted. And that's obviously going to have a great deal of interest for people who are worried about the following question. If a state holds an election in which the popular vote points one way and the state legislature decides to set aside that result and appoint its own presidential electors, can a state court intervene? Can a federal court intervene? In 1970, it's a no-brainer. No. But today, that's an open question.
Let's take a short break.
So we parked somewhere else, it was cold. Took a swing in the dipper, now the smaller world. So beautiful, when two souls have died in the world. Put a room on the dark star, market night he was. And got the charter coast. Steer us on through the cosmos, almost on our way. And you say, our fates always seem to intertwine. Obedient to your stars.
You're listening to I Hate Politics. I'm Sunil Dasgupta. Today we are examining the case to end judicial review with Maryland State House Delegate Vaughn Stewart and UMBC history professor Andrew Nolan. What would somebody like Ginsburg or Breyer or even Kagan or Sotomayor, right, would say about your view of judicial review, given the fact that they are trained in the system that venerates it?
Well, they would be horrified, right? They would be horrified. Obviously, they would be horrified. They were like, "Who is this? Who is this guy? How did people elect him to the state legislature? You know, he's like a proto-fascist. How dare he? You know, I mean, I think that there is a lot of obvious self-interest here. You know, I mean, I should say, like, as a disclaimer, I am a state legislator, so probably that does inform my views on these issues, right? I was popularly elected. As much as I have a lot of respect for Justice Sotomayor in particular, she wasn't. But I would suspect that, you know, there is a certain ideology that has absolutely permeated its court, most court watchers, most attorneys, most law schools and law professors, that essentially holds that judicial supremacy is off limits. Not only is it a great thing and a core feature of our democracy, but that this isn't even an appropriate conversation to have, that there's something sinister about even questioning judicial supremacy. They differ on a lot of things, but they would all be uniformly opposed to what I'm talking about today. And I think what is interesting is how much that flies in the face of basically what every other democracy does. So, for example, in Great Britain, their highest court does not have power of judicial review. Its job is basically to rule on decisions made by lower courts, but not to rule on whether laws passed by the parliament are valid. New Zealand has no judicial review. The Constitution of the Netherlands explicitly forbids judicial review. Finland, Luxembourg, Norway, Sweden, Switzerland, none of them have. And of course, these are all countries that rank near the top when you're ranking either quality of life or human freedom or ability to protect minority rights. And they basically all determine that, you know, the elected representatives of the people are the appropriate arbiter for constitutional issues, and seen as democratic, that the views of unelected justices should override the views of the people and of their legislators. Now, I think one interesting sort of middle ground that maybe would be a little bit more easy to swallow for the current justices or future justices or past justices is what Denmark does. So the Danish High Court, they essentially they essentially err on the side of caution. but they are willing to step in occasionally. So essentially, their practice is to mostly defer to the constitutional interpretation of the legislature, as long as it has, I think the term they use is some reasonable plausibility of being constitutional. Even if that interpretation differs from the majority of the court and how they would have preferred the Constitution be interpreted. And I think what's nice about this Danish approach is that it's very humble. It says that basically there can be more than one reasonable interpretation of a constitutional principle. Unlike many other countries, our Constitution is really old. It's a lot easier of a job to interpret when you have a 20th century Constitution and you have a lot of primary source material about what people meant when they wrote this word or that word. It's a lot more difficult to try to interpret our Constitution. And so that's why it's so easy to find multiple interpretations of it. But in the United States, sadly, we have a situation where the Supreme Court insists that its interpretation must always be applied, no matter how reasonable the interpretation of Congress or the presidency could be. But I'll just pivot back one more point to this idea of the background or the training of the justices, and also, of course, appellate judges too, or in district. I clerked on the U.S. District Court level. How much more professionalized or elite the Supreme Court justices now are expected to be versus centuries or even decades ago. And I think that actually speaks to some of the outcomes that we're likely to see in the near term and well into the future, because I'm not sure this trend is necessarily reversible. At least I can't foresee it reversing. You had someone like Justice Robert Jackson, who was appointed to by FDR, who had a high school degree. And then, at the time you didn't need to go to college to get your law degree. And so he just went, basically, I think he was trained by an uncle or some such in the law, and then basically passed the bar after that. And that was very ordinary. And then, when we talk about the Warren Court, one thing that allowed that to happen, or two things. One, speaking of the Great Depression, basically a majority of the Warren Court, particularly after LBJ was able to make some appointments, is you had a situation where a majority of the Warren Court essentially grew up in poverty. When you look at the backgrounds of the sort of key majority, the key five of the Warren Court during its peak, they all grew up, had either very, very hard scrabble or at least working class upbringings. And you saw that, I think, reflected in a lot of their rulings about, for example, welfare recipients. And they also had much more heterodox backgrounds. Now you have a situation where nearly every Supreme Court justice is born at least middle class, if not upper class. And they all essentially, the only real diversity on the court in terms of background is whether they went to Harvard or whether they went to Yale for law school. And I think it's only natural that the only minority group they seem to want to protect are corporations. And I think that speaks to, not only Democratic, but Republican appointees. I mean, obviously, the Republican appointees I consider, hard right wingers. I have a lot of respect for a lot of the liberal justices that we've seen for the past few decades. But, I think someone like Ruth Bader Ginsburg is a good example of someone who was absolutely adored. I mean, basically revered to an extreme level by most liberals in this country, but who scarcely found a time where she did not rule alongside the Chamber of Commerce on some of these business cases. And that may be a little bit of an overstatement, but someone like RBG was part of why the Supreme Court went from ruling with the Chamber of Commerce about 50% of the time, say 20 or 30 years ago. It was more of a coin flip situation, where now they're trending towards ruling with the Chamber of Commerce's position about 85% of the time. And that was something that didn't just happen among conservative justices. A lot of those decisions were 8-1 or 9-0 decisions that the liberals joined. And I think a lot of that has to do with the backgrounds of some of the justices today versus back then. I think the other part of why the Warren Court was created and why I think it's going to be very unlikely that happens again is that it took a ton of happy accidents for the Warren Court to happen. And we could have a whole podcast to go through them. But essentially, the short version is it took a lot of really timely deaths. And it also took a lot of really bad, dumb appointments, including 2 from President Eisenhower. One by appointing Earl Warren himself, which he later said was the worst decision of his presidency. And also he appointed William Brennan to the court, who was a huge liberal staple of the Warren Court for years. Without those 2 huge missteps by Eisenhower, without some subsequent missteps by other Republican presidents, who appointed people like Justice Stevens and Justice Souter to the court, who tended to vote in, among liberal lines. Without some of those huge whiffs, the Supreme Court would have been even worse than what we're talking about. And I don't think that that's ever going to correct itself. I think we're going to continue to see Harvard and Yale. I think we're going to continue to see people born with more affluent backgrounds, because we require our Supreme Courts to be so experienced and so smart, such good writers. We value all of that these days, rather than actually valuing what their ideology is or how much empathy they have for minority groups. We value sort of these elite things, these trappings of essentially privilege.
So Vaughn, just to follow up, you're saying that the likelihood that, and I'll pick a hypothetical, a 33-year-old from Anniston, Alabama would be appointed to the Supreme Court has shrunk.
Well, yeah, I mean, and listen, that's absolutely true. But listen, I'll say I went to NYU for law school, and normally you would think that, I think it's like a top 5 or top 6 law school.
Yeah.
That would be quite an extreme anti-elite diversity move if they appointed someone from NYU Law School. Now, I will say, I will give President Biden credit, because I sort of criticized him earlier, but I think Justice Jackson's recent appointment to the Supreme Court is hopeful in one respect. Now, obviously, she did not grow up overly wealthy. She does have an extremely elite background, and of course, that's what liberals tend to trumpet about her. Other than bringing some much needed gender and racial diversity to the court, liberals tended to talk about how experienced she was, how she was one of the most experienced nominees of all time, and one of the smartest, right? But I think the most exciting thing about her nomination, perhaps, was the fact that she was a public defender. And I think professional diversity is something that also we've completely lost on the Supreme Court, where basically every justice tends to have a background as either a prosecutor or as a lawyer for corporations. We almost never see for any federal judge, Supreme Court, appellate district, we very rarely see people with backgrounds representing either civil plaintiffs or criminal defendants. And I hope that changes. I mean, that would be one change that would make things a lot better. Now, it wouldn't fix the problem of judicial supremacy.
You're talking about how we need to start questioning judicial supremacy. And what fascinates me is there's a reason that Marshall would not go back to judicial review for federal laws, in part because he worried about maintaining the court's power. So he always wanted to keep that as something that was potential. Whereas Tawney used it in Dred Scott to try and settle the question. He was trying to say, by ruling the Missouri Compromise of 1820 out of bounds, he was trying to settle the question of slavery once and for all. And it failed miserably. And I think that that's something that the court could historically take notice of, that whatever decisions they release, they've been piling them up. I mean, you mentioned a lot of them on. There's Shelby County, what they've been saying about campaign finance reform, what they've been saying about voting rights, what they're getting ready to say about the rights of privacy. I'm not sure that people are going to simply accept these. And I think that the pushback they get is going to come through a variety of venues. I think there will be popular protests. I think there will be electoral protests. And I think that as a result, their ability to wield that power will be called into question, just as it was in the 1850s when Tawney tried to use it, mistakenly believing he would get deference, and he got exactly the opposite.
The more backlash and the more controversial opinions the Supreme Court does, the more likely it makes it that there is a popular uprising against its power. And I think that's the only way long term that we can create a healthy democracy and a healthy system. But it's going to involve a lot of pain in the interim for a lot of people. And I also, just to add one thing, Sunil, to a question you asked earlier, I think the most famous opinion I can think of, and of course it's complicated because DC is a federal entity. The most recent and famous example of the Supreme Court striking down essentially a state or local provision was in DC versus Heller, where by a very narrow majority, they basically upheld the common conception of the right to bear arms in the Second Amendment. I mean, by one vote, we were pretty close to having the Second Amendment essentially gutted. I mean, I think it's pretty clear that the founders couldn't have possibly envisioned a scenario where the Supreme Court would be striking down laws meant to restrict access to weapons of war so we don't have child massacres. I think that would be completely, unbelievably, it would be impossible for the framers to have envisioned that their one sentence about muskets would have possibly created this situation. But I think that is the most famous example of the Supreme Court striking down a sort of local or quasi-state provision, but they do it all the time. The Fourth Circuit Court of Appeals struck down a drug pricing law that the Maryland General Assembly passed a few years ago. And it looked like the Supreme Court was ready to affirm, but they instead just didn't rule, just didn't weigh in. And so that it was de facto, they affirmed. The beautiful thing about questioning Marbury versus Madison or questioning judicial supremacy is that President Biden could do this today. He could just issue a press release, say that he thinks that Marbury versus Madison was wrongly decided, and that he's now going to view Supreme Court decisions as advisory. And so if the Supreme Court tries to strike down, for example, his new plan on student loan debt, he's going to take what they have, what they say into consideration, but he's not going to feel bound by it. And he could do that. And that may trigger some sort of constitutional crisis or what have you, but at least it's within his powers. We don't have to rely on the Senate to pass a law. We don't have to rely on a constitutional amendment. We don't have to rely on some sort of, court packing thing. And what's interesting, I know I'm kind of going off on a bit of a tangent now, but I think what's interesting about court packing is that I think the inherent logic around court packing essentially is consistent with what we're saying, but it's just a more roundabout way to get there. Because essentially what court packing said is that presidents should have the ability to compose a Supreme Court, president, especially when they have unified control of Congress, the president should essentially have the ability to create a Supreme Court in their own image, which is essentially a roundabout way of saying that we should not have the Supreme Court striking down laws willy-nilly all the time and everyone else being bound by it. It's just a really, really roundabout way of getting to essentially the same result.
I don't see Biden doing it at all. You know who I see doing it? If Trump wins, he might do it.
I was going to say you were going to say Trump.
So in a sense, the biggest fear of liberals is that, which is that, it'll be done what you ask, but it'll be done from the side that they don't want it.
Right. And absolutely. And this goes back to the sort of the goose and the gander point I was making earlier. And as a progressive, I absolutely shudder to think of President Trump going back into office and then continuing his march toward authoritarianism, right? And I too would love the idea that the Supreme Court would be a bulwark against that. And in a couple of cases it was. But I think the reality is, with the current composition of the court, the likelihood that Trump may be able to, if he got back in office, he'd be able to reinforce that majority even more. Because what you'd see is, Justice Thomas, at least, and maybe even Justice Alito would step down strategically during that Trump term to make sure they can get younger. I think one of the Trump advisors said that, like the spoilage date, like the goodbye or fresh by date for judicial picks was 55, And so I think, Trump had no problem appointing people basically my age to some of the lower courts when he was in office. And so I think while it's extremely tempting, right, to say, oh man, that would be so bad for Trump to do that, we need the courts to stand up against him and all the MAGA Republicans who are, they hate democracy, right? A lot of folks like Mike Lee has come out and said that they don't think we live in a democracy. They don't like democracy. And it makes sense why. That's a rational view on their part, because most of their opinions are against the majority of the people. Essentially running on a platform of redistributing money from the majority working people of America to the minority shareholders and corporate CEOs is not a popular platform. And so they have to rely on things like the Electoral College, the filibuster, the Senate, and the Supreme Court to adopt their views. Because if we had a purely democratic system, they would be really hurting. And so I think, while it's tempting, I think at the end of the day, if you're a progressive, but really if you're just an American, I think that we would be better off. We would have better outcomes. We would have a better form of democracy if the Supreme Court was reined in a bit.
In the state of Georgia right now, there is a race for the U.S. Senate pitting Raphael Warnock, who has been by most measures an excellent senator for the state of Georgia, against Herschel Walker, who by all measures was an excellent running back for the University of Georgia. And if Walker beats Warnock, I think that's a tell right there about how things are going to go moving forward. And that would underscore the bleakness that Vaughn's talking about. That being said, there have been bleak times before, and I think it is citizen activism that changes this. Let's not lose sight of the fact that whether it was African Americans, whether it was women, whether it was Latino or Native Americans who were fighting for rights, they were deliberately breaking the law of the land in the name of the Constitution. In other words, that's the whole point of civil disobedience, is to do something that is illegal, that you know you will be punished for, in order to call attention to the fact that you were failing to live up to the constitutional compact, which you all agreed to. So bleakness perhaps, but I think we have seen in our lifetimes citizen activism. And I have no doubt that citizen activism will continue, not just voting, but taking actions to give life to the rights and the responsibilities that citizens of the U.S. hold. So again, as a historian, I'm terrible at the future. But I think if you look at the past, you will see people refusing to accept the status quo when the status quo forces them to see themselves as less than human.
Andrew Nolan, Vaughn Stewart, thank you for coming on I Hate Politics.
Thank you very much for having me.
Thanks very much. It was an honor and a privilege.
Normally at this time, I draw lessons from my conversation with my guests, but this week they have taken a big cannon shot across the bow, which is loud and clear, if anything. So that's all for this episode. You've been listening to I Hate Politics. I'm Sunil Dasgupta. Music for this episode comes from the Treading Lemmings, a Rockville-based Britpop band in the genre of the Smiths. Their music is available on ReverbNation.com. If you want to share your music on the show or know someone who might want to, please email us at ihppod@gmail.com or reach out on Twitter at ihppod. I hope you'll subscribe and share the show as we bring you stories about politics close to you and to your home. Happy 4th of July, even in these circumstances.
It's about